important that the Minister is saying to us that he has, I won't say reservations, but he has issues with the legislation which was put in place 10 years ago, that he will be reflecting on it and he will be presenting a more full response. But insofar as what is before us this afternoon, I support the Minister's intention to progress it and to move on with it, and I'm sure it will be the majority view of this House, Minister, that the legislation be approved.
Mr. Van Turnhout.
Thank you very much, and Minister, you're very welcome to the House. My remarks too will be brief. The purpose of the framework decision on the European arrest warrant is to create a common area of security, freedom and justice within the European Union, and one of the corollaries of the free movement of persons within the EU is that there should also be free movement of judicial decisions, whether they are in the form of sentences, convictions or judicial decisions to institute criminal proceedings. And I believe it's very important that we avoid the creation of places within the EU where there is a perception that the country in question is a safe haven for fugitives from justice. And I recognise that by enabling the provisions of the European Arrest Warrant Act 2003 to apply to states other than EU member states, we're reducing to some extent the chance of that happening. I also recognise that there is a number of criticisms and shortcomings around the legislative framework governing the European arrest warrant procedure. And so, Minister, I very much welcome your acknowledgement today in your opening remarks that the piecemeal approach to amending the European Arrest Warrant Act 2003 is unsatisfactory, and I further welcome your commitment to initiate a fundamental review of the legislation and to thoroughly examine our European arrest warrant procedures to determine how they can be streamlined and simplified. I just have one specific comment, Minister. I've received a lengthy submission in relation to the extraterritorial exception under Section 44 of the 2003 Act. A concern has been raised about the manner in which Section 44 is currently drafted, and I believe this is maybe what Senator O'Donovan was also mentioning. Its application to future cases, particularly in light of the recent Supreme Court decision in Minister for Justice, Equality and Law Reform versus Bailey, which was delivered on the 1st of March 2012. And I don't purport to make any comments on the rightness or wrongness of the decision in the Bailey case, and I most certainly do not purport to be an expert in international extradition law. I'm, however, interested to explore the contention made in this submission, the very strict interpretation of extraterritoriality based on the principle of reciprocity, whereby it is not open to the state to surrender a person for an extraterritorial offence unless the offence can be prosecuted in Ireland on an extraterritorial basis, given the rise to the possibility of Ireland being a safe haven for prosecution or sentence in certain circumstances. And so I do intend, Minister, to give this submission that I received further consideration in advance of committee stage, and I felt it was appropriate to say it today. And I will provide the Minister with a copy of the proposed amendment for his consideration, because I do have great trust, Minister, in your wisdom to ensure that the bill will strike the appropriate and right balance. And I wanted to highlight at this stage that this is the only concern that I have. Thank you.
Senator Bacic.
Thank you, Cahirlik, and I'd like to welcome the Minister to the House. As Senator Bradford has said, you're a very regular visitor, Minister, and to welcome the bill. I suppose the only note of non-welcome I have is that it's a bill that started in the Dáil rather than the Seanad. And I do want to just put on the record, Minister, that it's much appreciated that you have started quite a number of justice bills here in the Seanad, and we certainly hope you'll continue